For the past few weeks here on Property Matters, we've been exploring the local housing market. We've walked you through the process of finding the right home at the right price and how to submit your offer to purchase. The next step is to navigate the sometimes tricky bond registration process. There's a fair amount of legal terms and conditions involved, but we're going to simplify it all for you to make sure you dot all the I's and cross all the T's. To help me do just that is Anastasia Hajipavlo, property law expert and conveyancer at STBB Attorneys. Let's go meet her. Anastasia, please can you explain to us the process of registering a bond?
Sometimes buyers require a bond in order to finance that purchase. They need to understand that they need to be ready to apply for that bond as soon as the offer has been accepted by the seller. They can either personally liaise directly with the banks or engage with the professionals to assist them in obtaining the bond. The sale agreement, together with all the necessary documentation that is required for the application, will be submitted to the banks. And once the banks are ready to grant a bond, they will submit a quotation to that buyer. Upon acceptance and signature of that quotation, the bond is granted. A bond attorney will then be appointed to attend to the registration of the bond. The bond attorney will draft all the necessary documents in terms of the instruction received from the bank. They will make an appointment with the buyer to sign all the bond documents. Once they've signed those documents, the guarantees are issued. That is that document that confirms to the seller that the bond is secured.
Now, in the transferring process from seller to buyer, who pays for what in that process?
Let's start with the seller. The seller pays the estate agent's commission. The seller also needs to ensure that he or she provides the purchaser with all the certificates as confirmed in the sale agreement. If there's a bond on the property, an existing bond in the name of the seller, that bond needs to be cancelled simultaneously with the registration of the transfer. That bank will appoint a conveyancer to attend to the cancellation of that bond, and the seller pays the fee in cancelling the bond. The seller also needs to ensure that the purchaser doesn't inherit any liabilities with regards to rates and taxes and municipal accounts. So the seller will pay the figures that are issued by the council. The buyer will pay the transferring attorney's costs in order to register that transfer. The buyer will also pay the bond registration attorney's costs. The buyer will pay those costs for the issuing of the certificates, which also includes the issuing of a levy clearance certificate if the property is a sectional title.
Okay. How long does a bond registration process take?
The average turnaround time for a transaction is 8 to 12 weeks. Sometimes a lot faster, sometimes a lot slower. It is very important for us as conveyancers to manage the seller and the buyer's expectations and to communicate with them regarding the timelines in the transaction.
Thank you, Anastasia. Sometimes all the legal jargon can seem overwhelming, but the bond registration process really doesn't need to be a cause of anxiety as long as you have a knowledgeable expert on your side to guide you through the various processes. But it is also your responsibility to stay on top of every part of the process, see it as an opportunity to learn. Ask questions, do your homework, and don't let the legal jargon intimidate you. Luckily, this process is very systematic and there are checks and balances in place to safeguard your interests. So if you've done the groundwork, this is the part where you can sit back, relax, and let the attorneys do what they do best. And congratulations, you're almost a homeowner.